we're going to talk about specimens. No, I'm not talking about blood or fingerprints or bodily fluids. When filing an application alleging use of a trademark, you have to provide proof of that use for goods and/or services in commerce. Let's talk about goods first. The specimen must show actual use of the mark on the goods, on containers or packaging for the goods, on labels or tags affixed to the goods, or on a display associated with the goods. Labels or tags that appear to be a mock-up, illustration, or other rendering are unacceptable and will result in refusal for failure to show the mark in actual use in commerce in connection with the goods. In my last vlog, we talked a lot about specimens and ornamentation specifically related to International Class 25 or clothing. However, the modern specimen can consist of a website screenshot. If you're going to submit one of these, though, you're going to need to make sure the URL and date accessed information is visible in the specimen or otherwise included in the application. If you don't do this, you will get an office action. Also, if you sell goods, the website link should be a point of sale display. The Trademark Manual of Examining Procedure provides examples of good website specimens for goods, showing how a mark is associated with the goods are pictured and described, and the point of sale information is provided. For trademarks that are a scent, flavor, or similar non-traditional mark, you must mail the scented or flavored goods to the USPTO, and you cannot submit these electronically. Here's a tease. A scent vlog is coming soon. The examining attorney will evaluate specimens to see if they've been digitally altered or created. This means that you should not Photoshop a tag onto your goods and call it a specimen. This can also include images that are retouched. If you sell music, you can't just send a digital screenshot of your album artwork. You'll have to show a physical CD with the logo. Or if you sell your music online, you will need to show that the music is available for purchase. You can do this by including a screenshot of the item for sale on iTunes or Amazon or another website where you can actually click to purchase the song or album. Advertising material is generally not acceptable as a specimen for goods. If materials function simply to promote the sale of goods, this does not support trademark use. If you want to use folders, brochures, or other materials that describe goods and their characteristics, or serve as advertising literature, you must submit evidence of point-of-sale presentation. Order forms, invoices, and stationery are generally not acceptable as specimens for goods. Now that we've talked about goods, let's talk a little bit about services, such as legal services. Unlike for goods, a specimen for services can include advertising. The specimen must show direct association between the mark and service. You can submit letterhead, business cards, or invoices if they create a direct association between the mark and services you provide. If your services are entertainment services, you can submit a photograph of the group with the name also displayed in the photograph, such as on a banner or on the bass drum. The USPTO acknowledges issues associated with technology-related services because those areas are always evolving. A practical example of specimens for technology services includes a screenshot of a login screen with the name and/or logo and services displayed for cloud-based services. If your services are video games, you can often use a screenshot of an on-screen graphic displayed at the beginning of the game. For arguably the best game in history, The Legend of Zelda: Breath of the Wild, Nintendo submitted the jacket of the game itself as a specimen. This game had truly beautiful title cards, such as this one, that they could have submitted as a specimen. This is a lot of information to take in and process, but it shows the need to hire a trademark lawyer to help you navigate the process and make sure your specimens are correct. Because while this may be stressful to you, to your trademark lawyer, trademarks are fun.